Good morning.
Good morning, sir. How are you?
Good, good. Seth Goldner appearing for the Buckles office.
Okay, for Discover Bank.
Versus Lab.
Okay, got it. Okay, thank you.
Very well.
It's scheduled at 9:15.
I'm sorry. Perhaps I have an earlier appearance at 9.
Let's see, which one would that be?
Give me a moment, I'll tell you.
Okay,
I think I'm a little earlier. I thought my docket started at 8:30, not 9. Okay. So this must be Dunlap?
I'm sorry.
Oh, the other case that I have this morning in front of Judge Martin, scheduled for 9:30. And
Oh, right, yep, I see that one.
so I'm just really early for everything. I got it.
Well, this is gonna be a good day for you then.
Well, let's put it this way. I have time to drink coffee. So I think what I should do is probably just check back in with the court at 9 and then be ready for the 9:15 and etc.
All right, sounds like a plan. We'll see you then.
All right. Sorry for the confusion.
No problem. See you in a while.
See you in a few.
Okay.
Bye-bye.
Bye.
Good morning. This is Tuesday, November 16, 2021. I am Judge Martin, and this is the civil docket. If you're not here for a civil matter with Judge Martin, you are in the wrong courtroom. You should check your notice and log on to the correct meeting room. The other thing is that this court is assigned to do arraignments today, so our docket might be interrupted by arraignments from time to time, but I will return to the civil docket as quickly as possible. Mary Ann, is there anything ready?
I don't see anything that matches up yet, Judge. The gentleman who just came on that has iPhone, what is your name?
Yes, John Lyle,
Thank you.
welcome.
Mary Ann?
Yes,
Judge,
good
two
morning.
of us are here on one of the cases.
I'm sorry?
Two of us are here for a pretrial. Jim McCardle and me,
Okay.
Ron Ruark. We're here for a pretrial.
Thank you.
I'm sorry, Mr. Roark, you said you're here with whom?
Your Honor,
You're
it's
muted, sir.
Jim McCardle on behalf of the plaintiff cavalry.
Thank you. Are you ready or do you gentlemen need to speak?
We spoke yesterday. I think we're ready.
This is 211045 GC Calvary SPV 1 LLC versus Susan Wilhelm. May I have your appearances, please?
Again, Your Honor, Jim McCardle appearing on behalf of cavalry, the plaintiff.
Ron Ruark for the defendant, Susan Wilhelmy.
Today is the day and time set for the final pretrial in this matter. How are we proceeding this morning?
Mr. McCardle and I talked yesterday, I believe it was, about the case. I was suggesting we go ahead and get a trial date a few months into the future, but it looks like we're going to be able to resolve things.
It's not a few months into the future. Our trial date will be December the 6th at 9 a.m.
Fine with the defendant, Your Honor.
That's fine with me, Your Honor.
December 6th at 9 a.m., live or Zoom.
I much prefer Zoom, Your Honor.
That's fine, Your Honor.
Zoom trial, December 6th, 2021 at 9 a.m. If you resolve the matter before then, please submit the paperwork to the Civil Department for entry. Anything else, Mr. McCardle?
No, Your Honor.
Anything
No.
else, Mr. Roark?
Nothing, Your Honor.
Thank you so much, you gentlemen. Have a great day.
Thank you,
Thanks,
Your Honor.
Thank you. Mr. Anstanding, if you can get Mr. Robinson on the phone, if you mind checking, see where he is.
I'll do that, Judge.
Thank you. Mr. Goldner, good morning, sir.
Good morning. Can the court hear me?
Yes, sir.
What a pleasure.
What are you here for?
Your Honor, I am here for TD Bank versus Karen Dunlap at 9. Excuse me.
It's 9:30 case.
Yeah, you know what? I'm here on another matter. I'm sorry, for 9:15. That's Discover Bank versus Lyle, and I apologize.
Lyles. Mr. Lyles is here.
Lyles, yes, pardon.
This is 211067 GC. This is Discover Bank versus John Lyle. May I have your appearances, please?
Your Honor, for the plaintiff, Seth Goldner of counsel of Buckles and Buckles, on behalf of the plaintiff, Discover Bank.
John Lyle,
Thank you, Mr. Lyle. Today is the day and time set for the final pretrial in this matter. How are we proceeding this morning, Mr. Goldner?
Your Honor, if I may, this case has presented us with an allegation of fraud as a defense, which we're investigating at the moment. I understand there's been a prior adjournment. Based on the discovery that plaintiff has received so far, we believe that another adjournment would be appropriate to allow us to do some further investigation. The allegation from the defendant, as I understand it, is that a third person obtained his access to his information and fraudulently opened the account, if I read the answer correctly. We've had a first round of written discovery, which has indicated obviously a certain amount of information. What we'd like to do right now is we're trying to obtain proof of the use of the card to see if there's any signatures with any of the vendors, et cetera. I can tell you that we remain skeptical of the allegations that somebody was able to not only open up an account, but to use the account and intercept all statements. Our understanding on the account is that there's been payments made. That's not something you usually see in a fraud situation. So, Your Honor, we do think further investigation is warranted here. And I mean, on the other hand, hey, I mean, if in fact the defendant is the victim of fraud, we believe going forward, perhaps he should be required to file a third-party claim in the event that he has another individual that he might have authorized to use the card, contrary to what his statements are. Again, we don't really know, but our job is to investigate and make sure. And the type of fraud he's claiming and the facts that have surfaced so far to us bear further investigation, especially to figure out who actually opened the account, if we can determine that, and especially to investigate some of the charges. If it was all fraudulent, there shouldn't be any credit card slips or receipt signature on it, et cetera. And you know, we just want a chance to go with the evidence where the defendants where his defenses are taking us. At the moment, though, it's very unclear.
Mr. Golder, my only concern is that this fraud allegation has been out there since May. This is now the fourth time the parties have appeared. So how much longer of an adjournment are you looking for?
Well, Your Honor, you know, my normal inclination would be to ask for 45 days, which is certainly less than 60. Our problem here is we specifically want to go to vendors and see what information can be gathered about who actually used this card. In the alternative, I mean, our position is that the defendant, by the way, the spelling on the notice I have is L-Y-L-E. So I thought I heard the court say Lyles with the S at the end. But anyway, we believe Mr. Lyle is in fact responsible for all usage of the card. We do have a pending motion, which I think we're going to want to amend a little bit. But again, if he thinks somebody has used his card and is indebted to him, it would seem procedurally it would be upon him, with the court's permission, to file a third-party claim, because he seems to know who the individual is. He seems quite certain, again, from the discovery we've read, that he has been defrauded. And again, to us, it's sort of an open question as to whether or not it was fraud or permissible use that he doesn't want to admit to. Procedurally, that's where I see us at the moment.
Thank you, sir. Mr. Lyle, do you have any objection to this matter being adjourned for 60 days?
No.
Mary Ann, would you look at the January 4th docket for me, please?
Yes, give me 1 second.
Yes, ma'am.
Taylor, if you can hear me, I don't have the civil calendar up on my JS. Do you? And can you check that with the judge?
Your Honor,
Yes, sir.
if I may say, this is my first time appearing in your courtroom. It's a real pleasure to see you on the bench.
Good to see you, sir. Thank you.
Thank you.
January 4th at 9 a.m.
And Your Honor, that'll be the date and time for the final pretrial and plaintiff's motion for summary disposition.
Final pretrial and the motion for summary disposition.
Your Honor, I appreciate your courtesy and consideration on this matter. Thank you very much.
Anything else, Mr. Goldner?
Not at the moment. I do have a 9:30 case scheduled before the court. I'm happy to log back in.
Anything else, Mr. Lyle?
No, Your Honor.
Thank you, sir. Have a good day.
You too. Thank you.
Thank you. Mr. Robinson and Mr. Anstanding, do you need to speak or are you ready to proceed on your matter?
I think we're ready to proceed. I apologize, Your Honor. I was in Judge Green's court.
You're
And I
fine.
got Ron's
Were you done
message.
with
Thank
Judge Green?
No, I thought.
Oh.
I have a 9:30 with Judge Green, but I thought this was also with Judge Green, and then Ron just called and left me a voicemail. So thanks, Ron. I appreciate it.
You can't tell
Um,
Judge Green and I apart. I understand the confusion.
Could we go into a breakout room, Your Honor? I would like. a moment.
Absolutely. Marianne will send you an invite.
Okay, thank you.
Thanks, Judge.
Thank you. Mr. Davis and Mr. Willock. Are you ready to proceed, Mr. Davis?
Yes, Your Honor.
Are you ready to proceed, Mr. Willock?
Yes, Your Honor.
This is 211053 GC, Robert Davis versus Christina Kroneman. Appearances, please.
Good morning, Your Honor. Joshua Leland on behalf of the defendant, Ms. Kroneman. Good morning, Your Honor. Robert Davis, plaintiff.
Thank you, Mr. Davis. Today is the day and time set for the final pretrial in this matter. How are we proceeding this morning?
Judge, I have had an opportunity to discuss the matter over with Mr. Davis. Unfortunately, at this time, we have not met a resolution to the case. I have submitted discovery upon Mr. Davis. The 28 days has lapsed by quite some time as it relates to some requests for admissions. I'd be moving to have those deemed admitted. And then I would also request a date for motion for summary disposition. I think that would expedite this case.
You said, hold on, you said you sent something you didn't get. I was supposed to send you something?
That is correct, Mr.
You're
Davis.
supposed to respond to his discovery request.
Oh, okay. What did you need? I thought I sent you everything I had in text. I didn't know what else you needed.
Oh, Mr. Davis, there's a document that was mailed to you.
All righty. All right, well, I guess I'm gonna try to see what documents you need. And I sent you everything I had. We had discussed that when I first talked to you. Because I had bought a discovery pack and all of that. And I sent you the screenshots of everything. Of my estimates, the police report. I sent you all of that stuff, everything I had.
Oh, Mr. Davis, there was more in that document than just some of those documents that you had produced.
Okay, so that's my job to get all of the paperwork for you?
Mr. Davis, if you receive a discovery request from the plaintiff's attorney, I'm sorry, the defendant's attorney, it is your responsibility to respond to it. Not that you're doing his job,
Okay.
but
Okay,
that's
so
what
is that-
discovery is about for you. Hold on.
Oh,
Discovery is
sorry.
about you providing what you have, just like if there are things that Mr. Willock has that you want or questions that you want his client to answer, you send it to him in writing and he responds to it. His request is to set a motion date. What this court will do is provide a date of January 4, 2022 at 9:15 a.m.
Okay, so is there like a form or something I gotta get to respond to his motion?
Yes, sir. Not a form. You can just, your response is just the caption, number one, admit, deny, can't admit it or deny, that kind of thing. What I would suggest to you is you might want to contact legal services and see if they can provide you some assistance, or Michigan Legal Help is available online.
Okay, I just don't understand why we even keep having to go. I gotta keep taking off work to come to all these court dates when she
You
not
don't
here.
have to keep You don't have to keep taking off from work, Mr. Davis. What is it that you want to do, sir?
Well, I was just trying to get this case resolved. You know, the lady ran into my car and then like she's just not trying to like take responsibility for her actions. I'm like, you know, I've still been paying the car note on this car since January, since it happened. I'm just trying to get like this bill, you know, taken care of because it's, you know, financially taking the toll on.
Mr.
You know,
Davis,
and
is there a better time of day that you don't have to take off from work? Because we're Zoom and our hearings will only be, they've been brief so far. So if there's a better time of day for you to
Right.
schedule these matters,
Okay.
you have to
All right.
tell me though.
Oh yeah, like later on in the day would be fine. That would be perfect.
Later on, like what, Mr. Davis?
Like your latest case. I don't like know exactly what time your schedule is or nothing like that. Like,
What time do you get off of work?
man, I get off at like real late. So I get off like 5, 6.
What time do you work?
From like 5, 6 in the morning.
You work 12-hour days
Yes,
every day.
pretty much.
Mr. Davis, I can't accommodate you if you don't tell me what it is you need. If you tell me Tuesdays don't work because of X, but I'm off on Y, you tell me that, we can
Well-
try to be flexible. But I
Well,
can't,
yeah,
I can't guess
I'm
what your
just saying
schedule
any
is.
day will work, but like just a later time frame, like just a later, like your latest court date, you know what I'm saying? Time would be fine. That way I can
My
work.
latest time is 3:30. That's why I'm asking.
Oh yeah,
what's
see,
better
that's
for
perfect.
you?
Yeah, that's what I'm saying. Like your latest time frame, because like then I could work in the morning and have that time off. You know,
Mr. Whitlock, can you look at your schedule for, I'm sorry, Mr. Davis, I'm not trying to cut you off. I just see Mr. Ann standing and Mr. Robinson back. Mr. Whitlock, on the 4th of January, how late in the day could you possibly do a Zoom motion?
Judge, I can accommodate. I'm wide open on that day, so.
Mr. Davis, we will 3:30 p.m. on June the 4th.
Okay.
January,
we
Judge,
presumably will still be on Zoom.
Okay. All right. Yeah,
Judge,
because
that's January the 4th.
I got his packet here that he sent me. I just, you know. But all right, I'll take care of it. I'll get that stuff over to you, Mr. Whitlock.
And Mr. Davis, you are absolutely free to speak to Mr. Whitlock between now and January 4th. Don't wait until you're back here with me. You can communicate with him if there's some other way to resolve it or some outstanding question. But other than that, anything else, Mr. Davis?
No, ma'am. No, Your Honor.
Anything else, Mr. Whitlock?
Just a few things, Your Honor. Mr. Davis has acknowledged that he does have that package, that he has not answered that. The 28 days has lapsed. I would just like to preserve the record for those particular issues. And I think given the improper nature, I would ask the court for a motion file deadline as well as a response deadline for Mr. Davis to my motion for summary disposition, just so he has that on his calendar right now.
If we're back here on the 4th, that will put your filing deadline at December 7th. Is my math right?
We could put my deadline at December 6th, just for easy numbers,
How is that an easy number?
just for a Monday. 7 would work, Your Honor. We're going 28.
Mr. Whitlock, it doesn't matter to me. It's your motion that you have to get filed. Response cutoff would be, well, that's the holiday weekend. I want to put it 2 weeks before only because we have light civil department, well, the mail situation. December 20th. You said a few things, Mr. Whitlock. So other than the motion deadline, the filing deadline, December 6th, and response deadline, December 20th, what else did you have, sir?
Judge, just to preserve for the record that Mr. Davis has failed to timely answer that request for admission within his 28 days.
I did.
Hold on, no. See, we're not gonna do that. He acknowledged receipt of it. You can have different conversations with each other offline. Everyone doesn't need to be part of this conversation.
Oh,
I
okay.
thought Mr. Davis' position was that he had responded to you. And if you file a motion that says he did not respond and he produces proof that he responded timely, that's something we'll take up on January 4th, okay?
Thank you, Judge.
Other than that, Mr. Wellock, anything else?
No, Judge.
See you back here on January 4th. Thank you very much.
Your Honor.
Thank you.
Your Honor.
Mr. Davis, yes.
Yes, ma'am. Hey, what did you say the name of that legal service was? You said I could call or
Is-
contact.
No, Michigan Legal Help is online. MichiganLegalHelp.com, I think, is the extension. I don't remember exactly, but
Okay.
there are legal services, information available, legal services available to you. They might not be able to represent you, but they might be able to provide you some advice and assistance.
Okay. Thank you.
Okay, thank
Yeah.
you. Have a good day.
You too.
Thank you, Judge.
Mr. Anstanding and Mr. Robinson, were you kicked out or did you come out?
We came out, Judge.
Okay, this is 211470GC Comcast versus Blue Ribbon. May I have your appearances, please?
Good morning, Your Honor. Ronald Ian Standig, P30277 for plaintiff.
Good morning, Your Honor. For the record, Steve Robinson, P45753, on behalf of the defendant.
Today is the day and time set for the final pretrial in this matter. How are we proceeding?
Your Honor, although we defined it as final pretrial, if the court could give us just another 30 days on this, I'm pretty confident we can get this resolved. So can we have a final pretrial?
Mr. Robinson.
I would not object, Your Honor.
December 7th at 10:15 as the final pretrial. December 7th, 2021 at 10:15 a.m. That's back with me in courtroom number 1. Anything else, Mr. Anstanding?
No, Your Honor, I think that's fine.
Anything else, Mr. Robinson?
No, Your Honor. I'd just like to take the opportunity to say hello to my buddy Seth Goldner. I haven't seen him in ages.
Well, you better get back to Judge Green then. Thank you, Mr. Robinson.
Thanks, Judge. Take care.
Thank you, Judge.
Mr. Goldner, the court has received information that Ms. Dunlap is having trouble connecting to Zoom.
Oh, okay.
So they put her phone number in the chat, but we will wait to see what the situation. I know there was a problem with the connection. Nope, sorry. She is having trouble. We'll see what happens because clearly she was able to get on before.
Okay.
So we'll keep an eye out, and if it gets to be 9:30 and she's not connected, we'll figure something else out.
All right. Thank you, Judge. I'll just stay tuned in here and go about my business for a little bit.
Understood, sir. Thank you.
Thank you.
Is there anyone here for Belleville Quality Cleaners?
I am Sarah Cervantes Aragin.
No, ma'am, you are not here for the cleaners. I see you.
Oh, I'm sorry.
You're fine. The cleaners had some trouble connecting the last time, so we'll sit tight for a couple of minutes, and if they can join us, great. Otherwise, we'll again have to figure out something else. Sarah Thomas.
Yes.
Good morning, Ms. Thomas. How are you?
Good morning. How are you, Judge?
I am wonderful. I have not seen Daniel Fleming. Is there someone else here this morning for MB Moving Company? Your case isn't scheduled till 8:30. I'm sorry, till 9:30. It's 9:25 by this court's clock. My schedule usually is 15 minutes within. I try to call the case within 15 minutes of the scheduled start time. So sit tight, ma'am. Mute yourself back, and if your other side doesn't appear, I'll call your case at about 9:45. Okay.
Sounds good, Judge.
Thank you. And last time, Marion, I think what happened with the cleaners is that they called the court and couldn't get on while the plaintiff was on with Al Henman. Good morning, Mr. Fleming.
Good morning, Your Honor.
Do you need to speak to Ms. Thomas before the case is called?
I can, I mean, that's fine. We can speak.
Marianne will send you an invitation to go into the breakout room with her. Ms. Thomas, please join Mr. Fleming.
Okay, thank you.
Thank you. Good morning.
So you have your 1030 file.
Okay.
And then there's also one out of Van Buren. They do not want MIDC. So whenever is a good time for you?
Whenever they come on.
Do you want me to call them now?
Yeah.
Is now a good break? Okay.
It's not a good break, but I already told everybody that this is arraignment courtroom too. So whenever they're ready, Marianne will admit them and we'll get that case called. Thank you, ma'am. Thank you. Ms. Cervantes,
Yes.
would you turn your video on for me, please, ma'am?
Yes, of course. Just a moment, Your Honor.
Yes, ma'am. This is 213608SC. This is Sarah Cervantes.
Aragon.
Would you pronounce that? Aragon, thank you. Versus Belleville Quality Cleaners. State your name for the record, please, ma'am.
Sarah Cervantes Aragon.
Thank you. This is a small claims case that was originally scheduled for October 12, 2021. At the scheduled, I want to call it what is listed as on the notice. At the scheduled hearing date, the plaintiff appeared, the defendant failed to appear. What happened is that on that October 12th date, the person hearing these matters was working remotely. So while you were on with that person, the representative from Belleville Quality Cleaners called the court and indicated to the court that they could not connect. So rather than proceed when we know that there was a technology issue, this court rescheduled the matter to today, and it's not with someone else. I'm one of the judges here in the building. And it does not appear that any representative from Belleville Quality Cleaners has called in this morning. They have not logged on. I have called the case name now. I've called for Belleville Quality Cleaners previously. I don't see any message from the civil department that anyone's trying to reach this court on this matter and has not been able to join. Based on the defendant's failure to appear, send a representative or contact the court. Ma'am, how do you wish to proceed?
I would like the same result as last time.
Say it. You need to say it for me, please.
Oh, I would like to not reschedule if possible.
Ma'am, how much is owed to you?
$2,014.
Have you had any communications from the cleaners since you appeared on October the 12th?
I have not, Your Honor.
Based on the defendant's failure to appear this morning, the court will enter a default judgment in favor of plaintiff and against defendant. Ma'am, I am signing the form that you previously submitted to the court. I am dating the judgment today because we have called the case and the defendant is not here. Anything else in this matter, ma'am?
I do have a question. If the
Yes, ma'am.
defendant calls again later and says that there was a technical difficulty, could the same thing happen again?
No, ma'am, he'll have to file a motion, or they will have to file a motion to set aside the judgment. The matter was specifically rescheduled to allow them time to either physically come to the court, because this court has a room available for people to Zoom from, or to call the court or work out the technology problem beforehand. So
Okay,
that person has now had 2 bites at the apple to get here and has not done so.
okay,
Okay?
all right,
The civil department will mail the judgment to you.
okay.
Okay?
And then is there
Thank
any
you, ma'am.
paperwork I have to fill out on my end?
No, ma'am, I signed the
Okay.
judgment that was previously submitted. The civil department will mail it to you at the end of the day, or when they process it.
Okay, thank you so much, Your Honor.
Have a good day.
Thank you. You as well.
Good morning, Wayne County.
Good morning, Your Honor. How are you today?
I am wonderful, sir. How are you?
Very good, thank you. We may be a little early, but I have Janelle Foley. She's on.
I will take early all day, every day, sir. Not a
Yes,
problem.
ma'am. Thank you.
This is 194331 Huron Township versus Janelle Ray Foley. Ma'am, would you state your name for the record, please?
Janelle Ray Foley.
Ms. Foley, today is the day and time set for your arraignment. There was a bench warrant issued against you back on January 3rd, 2020, based on your failure to appear for a pretrial. Your bond was thereafter forfeited and the security discharged. The warrant has now been canceled, ma'am.
Thank you.
Your next proceeding will be a pretrial. That pretrial will be on December the 9th, 2021 at 10:40 a.m. And that will be back with me, courtroom number 1. I presume that we will still be on Zoom on December the 9th. Ma'am, are you in Wayne County for this or something else? Oh, I see the answer to the question, Ms. Foley. That's
Okay.
fine. Your bond in this matter will be reset at $5,000 personal.
Thank God. Thank you.
You're back with me again. File number is 194331 and you'll be back here on December 9th at 10:40 a.m. And just so the record's clear, there's a notation on the file that you waived the right to have the assistance of the court-appointed attorney this morning, correct?
Yes, ma'am.
Thank you. Anything else, Wayne County?
No, ma'am. Just you and your staff have a wonderful day, and thank you.
Thank you, sir. You too.
Yes, ma'am.
Good morning, Mr. Kirschenheiter.
Hi, how are you, Judge?
I'm good. How are you, sir?
Wonderful.
Are you early for your 9:45?
Yes, ma'am.
Okay. I have not seen Ms. Hill yet, so sit tight. We'll get back to you as soon as we can.
Sure, Your Honor, but she does have an attorney.
Yes, sir. Mr. Fleming, was that sufficient time with Ms. Thomas?
I think so. Sure.
Give me 1 second, sir. This is 212783 GC, Sarah Thomas versus Trisha Owadari, David Jones, and MB Moving Company. May I have your appearances, please?
Daniel Fleming for the defendants, Your Honor.
Sarah Thomas, the plaintiff.
Thank you. Today is the day and time set for the final pretrial in this matter. How are we proceeding this morning?
Judge, we've made some progress. This is a claim. Ms. Thomas claimed some damage to personal property as a result of a move. She hired my clients for some labor to help her move. I've inspected the property that she claims was damaged. We had her deposition scheduled just so we could go through everything. But due to some issues, that didn't happen. I guess Ms. Thomas didn't really know when that was supposed to happen. So she's agreed to a deposition next week, next Tuesday. So we can go through this and I can understand exactly what she's claiming.
Sounds like there should be something else after that, Mr. Fleming.
Well, I mean, once we get to that point, I guess we can assess. I discussed with her, maybe the court would put this case into case evaluation. I asked her what her, how she's going to prove her damages. So we're talking, I think case evaluation might be helpful.
If that is what you're requesting, sir, we'll make arrangements for that.
Okay. I think it would be helpful.
Good morning. Give me 1 second. To case evaluation, and let's leave a control date in here. January 4th. I'll adjourn the final pretrial out to January 4th, 2022 at 9:15 a.m.
Moving forward, and this is a great opportunity for them to use this investment to move those projects forward. As a former mayor of Boston,
Anything else in this matter, Ms. Thomas?
No, that's it, Your Honor.
Anything else, Mr. Fleming?
Judge, just a quick question. Will we go to case evaluation before this January 4th date?
Hopefully. I'll send the file downstairs for the order. I don't know what the mechanism is for the civil department to get it out where it needs to go. If that January 4th date needs to be adjusted, they will do that.
I see. Okay. And one last question, maybe I can talk with your clerk there, but we had sent in an order after the first pretrial. I don't think we ever got a copy back. Do we need to follow up and get that from the court?
Your order for discovery, sir?
Yes.
That was signed on 9/15/2021.
Okay.
I'll leave a note on the file that you need a copy.
Okay. Thank you.
You want an email or fax?
Email's fine.
Your email address?
D Fleming, FLEMING at Moblo, MOBLO Fleming.com.
When the virus is over, we'll be better. That's not the case.
I'll put the file to the side. We'll get the copy of the order sent to you.
Okay.
Anything else, Mr. Fleming?
Nothing today, Your Honor.
Have a good day.
Thank you.
Thank you. Let me get rid of one arraignment and I'll take care of you, okay?
Ms. Thomas, we'll
Van
talk.
Buren, good morning. I'm sorry?
We're good. I'm sorry, Judge. We're leaving.
You can log off. Thank you, Ms. Thomas. Have a good day. Van Buren, good morning.
Good morning.
This is 201025SM, 20VB019370M, 20VB01956SM, State of Michigan versus Dakota Daily.
Was his position written into the legislation?
Good morning, sir. State your name for the record, please.
Dakota Raven Lee Daly.
Thank you. Mr. Daly, there is a notation on the front of the file that you have waived the right to have the assistance of the court-appointed attorney this morning. Is that correct, sir?
Yes, ma'am.
Today is the day and time set for your arraignment on a bench warrant. The warrant was issued after you failed to appear it looks like back on November 10th, 2020. That warrant has now been canceled, sir. Your next appearance date will be on a pretrial on November 23rd, 2021 at 9:30 a.m. That will be with Judge Green in courtroom number 3. Again, this file number is 201025 SM, November 23rd, 9:30 a.m. with Judge Green. You have some other matters as well, sir.
Yes, ma'am.
The 20BB01937OM is a trespassing case from April 10th, 2020. There had previously been a warrant entered. That warrant has been canceled. Your next appearance date in this matter will be a pretrial on December 2nd, 2021 at 9:30 a.m. That will be with Judge Green as well in courtroom number 3. Your bond in this matter will be $1,000 personal. The other case is 20VB01956. This Sir, in this case, you have failed to make payments. You owe the court $240. Please either contact the court. You can go online to the court's website, make payment, or you can physically come to the building and make payments, okay?
Yes, ma'am. Sorry to cut you off. I thought I did pay it online, but maybe it did not go through. But I will, when I'm released, I will go straight and pay it.
Anything else, Van Buren, in this matter?
No, ma'am.
Thank you. Mr. Daly, good luck to you, sir.
Thank you. Thank you, Your Honor. Have a good day.
Thank you. Joe. Good morning.
This is a search warrant for cell site location information for ongoing.
I don't think I've seen you. It's been a while.
It's been a while, yeah.
Do you swear from the contents of the affidavit to the best of your knowledge, information, and belief?
Yes, Your Honor.
Thank you.
Thank you.
Would you give those to Andy when you get back down, please? You were trackers last time, right?
Yeah.
Jeez.
Now we're still in caution.
No. Sounds unbelievable, doesn't it, Joe?
The person who has the name of Jerome, can you hear me?
Yeah, I can hear you.
What case are you here for this morning, please?
The case number is 212498.
Oh, okay, you're not scheduled until 10:45,
Oh, okay,
so you may want to come back.
okay.
Okay, thank you.
Oh, I remember this now. Thank you.
They probably came through there because Van Buren comes through here, right?
Mm-hmm.
Yeah. They probably had this case too.
Mm-hmm.
Who's the one with, who's the yo-yo involved? Yeah. Doing all the way down to Grab Garden.
When I saw the July date, I thought, wait a minute, I remember this case.
I just called back yesterday. Thank you, Your Honor.
You're welcome,
Appreciate
sir.
your time.
Have a good day. Apologies for the interruption, gentlemen. There were a search warrant and a couple of arraignments that we had to get to. Mr. Goldner. Miss
Your Honor,
Ms. Dunlap still cannot connect, and I don't know what cannot connect means.
Your Honor, is she able to in any way telephone the court? We could conduct her side just by phone?
Judge,
I will do that shortly.
she can call in. Her internet's not working. She called her provider and just her internet's down.
Okay. She can call in as soon as we see her, as soon as we see the phone connect. I'll get the case called. If you can let her know that, give her the contact information to call in on Zoom.
Okay, I will.
Thank you.
Thank you, Judge.
Thank you for your patience, Mr. Goldner.
Happy to wait.
Have we seen? Is there someone here for Preston Nate?
I'm here on that matter, Your Honor, the Citibank.
Thank you.
Yep.
211964 GC. Citibank versus Terry Shoneth.
Here, Your Honor. Good morning, Your Honor. Brian Gruen, GROEN, P number is 56673 on behalf of plaintiff Citibank.
Mr. Shoneth,
Yes, I'm here, Your Honor.
state your name for me, please, sir.
Terry Shaneth.
Thank you, sir. Today is the day and time set for the final pretrial on this matter and the motion date. How are we proceeding this morning?
Your Honor, Mr. Shoneth is working with a debt settlement company, and we've been kind of pushing this out to give him some more time. And since the last adjourn date in September, we still have not received any type of settlement offer from AmeriCorps on this matter. So maybe he can speak to that, and based on his answer, we'll probably most likely will have to proceed with our motion.
Yeah, I'm prepared to give you some information in that regard. Are you listening to me, or can you hear me? Okay,
Yep,
fine.
yep.
There's a reason for the delay, that I had brain surgery in October, and that kind of stopped everything. I've got the thing back on track with the settlement company, and I've released some additional funds for them to go and talk to you.
Do you gentlemen need to go into a breakout room?
Your Honor, that's fine. I can speak to him shortly.
Okay. Marianne will send you an invitation to go into the breakout room.
Thank you, Your Honor.
Thank you.
Okay.
What, Ms. Dunlap has not called back. Good morning, Ms. Dunlap. Oh, still connecting. Mr. Goldner.
No problem. Yes, Your Honor. Hello.
She's connecting right now, just waiting for the audio to connect.
Oh, I think I see her joining us now. She even had a video for a moment.
Good morning, Mr. Brainer.
Good morning, Your Honor. How are you?
I'm good, sir. How are you?
Good, thank you.
It says Discover Bank.
Yes, that is correct.
Who is your other side?
So the other side here is Renee Baker, and the attorney on that is Nick Balberman. He won't be appearing this morning as we reached a consent judgment yesterday, which is currently in process of being mailed to the court.
I'm sorry, are you in the right courtroom?
I believe so.
Oh, I see you now. You won't be appearing because, hold on one second. Miss Dunlap is here. She's not connecting her audio though.
Sort of the opposite of what we need.
Uh, 212967 GC Discover Bank versus Renee Baker. Mr. Brainer, your appearance and you were starting to say.
Sure. Good morning, Your Honor. Attorney Jason Brainer on behalf of Discover Bank.
You were starting to say that you've spoken to Mr. Balberman's office and.
Yes, we spoke with Mr. Balberman's office yesterday, and we reached a consent agreement in this matter, which is currently in the process of being mailed to the court.
How much time do you need to get that consent in, sir?
It should be to the court, I would say no later than Friday. It's in the mail right now. So it should be there by the 19th. And then whenever the court receives it, we'll just
Hello?
be waiting entry on it.
Mr.
Hello?
Brainer, I put a note in the file within 14 days, okay?
Okay, certainly.
Anything else this morning, sir?
No, that's it.
Thank you, sir. Have a good day.
Thank you, you too.
Miss Dunlap.
Yes, I can hear you.
Good morning.
Yes.
This is 211311 GC TD Bank USA versus Karen Dunlap. Appearances, please.
Your Honor, may it please the court, Seth Goldner of counsel with Buckles to Buckles on behalf of TD Bank.
I can
Ma'am,
hardly
state
hear
your
you.
name. Miss Dunlap, are you able to hear me?
Oh, yes, I can hear you.
That was the attorney for TD Bank putting his appearance on the record. Today is the day and time set for the first pretrial in this matter, along with the plaintiff's motion for summary disposition. Ms. Dunlap, did you receive the motion from the plaintiff's office?
I saw that I was supposed to come to court, and then he sent a paperwork asking if I could make payments. Is that what you're asking me?
Yes, ma'am.
Yes, I
Mr.
saw
Goldner,
that
do you need to
paperwork.
speak to Ms. Do you need to speak to Ms. Dunlap?
Might be helpful, Your Honor.
Ms. Dunlap,
I
you're
can't
going
hear
to see
him.
you're going to see an invitation to join him in a breakout room. You're going to hit the button that says join.
Thank
Mr. Kirschenheiter.
Yes, Your Honor.
This is 212697 GC, Bank of America versus Patricia Hale.
Good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
And Your Honor, this is Attorney Trevor Stratton, P65124. I'm here for Ms. Hale.
Your Honor, we had a chance to discuss this matter. We've actually come to a resolution. We've agreed to a consent judgment with no collection activity for 60 days. And I'll be sending in that signed order to the court. It should be there within a week or two at the latest.
Mr. Stratton,
Yes, Your Honor.
is that accurate, sir?
Yes, it is.
Is there a reason why your video is not on, sir?
Yeah, I'm on my phone and my camera is non-operational at the moment.
Thank you. Mr. Kirschenheiter will make a note in the file that we'll have it within 14 days.
Sounds good, Judge.
Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else, Mr. Stratton?
No, Your Honor. Thank you.
Thank you. Have a good day.
You as well, Your Honor. Take care.
You too.
Thank you. Mr. Groen, were you able to get the information in 211964?
I believe so, Your Honor.
And for purposes of today's final pretrial in motion, how are we proceeding?
Your Honor, we're talking with the defendant, and basically what he told you on the record as well. He just sent in some additional funds, so he's hoping AmeriCorps will have enough in his account to contact us. So I told him we're amenable to push out our motion for summary. If the court is amenable to push this out one more time to give the parties a chance to settle. So if we could maybe push this out to a date sometime in January. If we don't hear anything from AmeriCorps at that point in time, we'll have to go forward with our motion. But I'd like to afford him at least one last opportunity.
We'll push the final pretrial and motion out to January 4th, 2022 at 9:30 a.m. We will presumably still be on Zoom. It will be back in courtroom number 1. Anything else on behalf of Citibank?
Not in this matter, Your Honor.
Anything else, Mr. Schoening?
No, I'd like to apologize to everybody for the delay, but I was physically laid up with brain problems.
Sir, do not apologize. Life happens. You joined us this morning. That's all that matters. You'll continue to work with your debt settlement agency, and hopefully this matter will be resolved before you need to return in January, okay?
Yes, I'm hoping to. I'm tired of it.
Thank you, sir. You have a good day.
Thank you, Your Honor.
Your Honor, I'm also
Citibank
here.
versus Khan.
Yeah.
Okay.
Thank you. Good
Mr.
morning.
Broad, I try to get to these. We're running just a little bit behind, not much though. This is 213508 GC Citibank versus Michael Khan. Your appearance, please, sir.
Good morning once again, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff Citibank.
Today is the day and time set for the first pretrial in this matter, Michael Khan. Michael Khan, this matter was scheduled at 9:45 a.m. It is now 10:02 by the court's clock. This court's usual wait time is 15 minutes. There is no one in the court's virtual courtroom by the name of Khan. There are no unidentified persons in the court's virtual waiting room. How do you wish to proceed this morning, sir?
Your Honor, similar to the last file, Mr. Khan is also working with a debt settlement company, and they actually have been in contact with us, and the settlement has been reached. We are just kind of awaiting the signed consent judgment back from them. So if the court is amenable to maybe just to adjourn this out once to see if we can get that signed consent judgment back during the interim period, we will get that filed with the court. If not, we may have to go a default judgment route at the next hearing.
We have a December 7th date, 3-5. December 7th, 2021 at 10:15 a.m. I'll put it as an adjourned pretrial date. If you are able to if you receive the signed consent back from the debt settlement company before that time, just submit it to the court. We'll get it signed and back to you. You won't need to appear on December 7th, okay?
Sounds good, Your Honor. I appreciate it.
Anything else this morning, sir?
I think that's it for me. Have a good rest of your day.
Thank you, sir. You too.
Thanks.
Ms. Katz
Good morning, Your Honor.
and Mr. Musa, good morning. This
Good morning, Your
is 212407 GC Suleiman Musa versus Insurances Auto Auctions. May I have your appearances, please?
Good morning, Your Honor. Erin Katz on behalf of the defendant.
State your name for me, please, sir.
Suleiman Musa.
Today is the day and time set for the first pretrial in this matter. Have the parties had an opportunity to speak? Are you ready to proceed this morning?
Yes, Your Honor.
Yes,
Your
which
Honor,
one, sir?
I'm sorry, we
Excuse
haven't
me?
had a chance to, we have not had a chance to speak. It might be helpful for us to go into a breakout room briefly just to discuss.
Mr. Musa, you're going,
Yes,
you
sir.
will see, you'll see an invitation to join the attorney in the breakout room. Please join her there. When you're
Okay.
done talking, you come back out and I'll recall the case.
Okay.
Thank you.
Thank you.
This is 213350LT. This is Rawsonville Woods versus Shatoya Victor. This matter is actually scheduled for 10:30 a.m. This court has received a message from the civil department that a dismissal without prejudice has been received. The court will sign it once it is presented.
Your Honor.
SC, you give me 1 second, please. Mr. Goldner,
Seth
yes,
Goldner
sir.
here. Is there a chance I could talk to Ms. Dunlap for a few more minutes?
Is there, yes. She'll put you back into the breakout room.
Thank you.
Ron Bach, I couldn't believe my eyes when I read my docket.
How you doing?
I am wonderful, sir. How are you?
I'm good. I just learned you're a judge right now as I looked it up.
Your other side is not here yet. You're scheduled at 10:15.
Okay,
You'd sit tight for a little bit. We'll get, as soon as somebody else gets here, get a match set, we'll get going again.
no problem. Thank you.
Must have been here now. Thank you. Thank you.
Okay.
As I throw stuff all over the ground. Don't be in a rush to leave here. Good morning, Mr. Day.
Let's see.
Ms. Katz and Mr. Musa, are you ready to proceed in 212407?
Yes, Your Honor.
Yes, Your Honor.
How are we proceeding this morning?
That's good.
Your Honor, if, I'm not sure what the court's usual procedure is as far as entering a scheduling order, but we'd like some more time to attempt to resolve this. So either we could enter a scheduling order or adjourn a pretrial conference for a short period of time.
Ms. Katz, are you looking for discovery period for a motion, or are you just looking for more time to talk?
At this point, I think we'd just like some more time to talk.
Is December 7th enough time, or would you like to go over to January 4th?
December 7th is good for me.
And it's good for me
Mr.
too.
Musa, December 7th
Yes, Your
at
Honor.
10 a.m.
All right.
We will adjourn the pretrial to December 7th at 10 a.m.
Okay.
Expect with me in courtroom number 1. We will presumably still be on Zoom. December 7th at 10 a.m.
Okay, Your Honor. Thank you so much.
Anything else, Mr. Musa?
That's all. Thank you so much.
Anything else, Ms. Katz?
No, Your Honor.
Have a good day.
Thank you so much.
Bye-bye.
This is 213675 GC. Manor versus Manor.
Morning, Your Honor. John Day appearing on behalf of Ron Manor.
Good morning, Your Honor. Tracy Geisbert appearing on behalf of Dakota Manor.
Do the parties need an opportunity to speak?
Mr. Day, I don't know if we need to talk, or I did email you a letter last week, so we've, Mr. Day and I have been.
I discussed that with my client and we're still a little ways away.
Okay.
I'm going to put a pin in you for just 1 second. We have an earlier case that's had some technology problems, so I want to handle this while we have them. 211311 TD Bank versus Dunlap. Mr. Goldner, was that sufficient time with Ms. Dunlap?
Yes, Your Honor, it was very helpful, and I appreciate the opportunity to talk to her more. So I've had a long chat with Ms. Dunlap. We're at pretty much an impasse. I've explained to her, if I can summarize, I've explained to her.
Mr. Goldner,
Yes.
I can barely hear you, sir.
Let me check my microphone settings. I don't know why that was the case. They turned down on me. Is that a little better?
That's wonderful. Thank you.
Thank
You were
you.
saying you had a long conversation with Ms. Dunlap.
Yep, I asked her, based on her answer, if she would execute a consent judgment. She is not wanting to do that. I indicated to her that we're interested in verifying her financial hardship, but now is not the time. And that, my job would be to argue our motion for summary disposition, which I do believe is pending for today. And then I told her, depending on whether you decide to grant the motion or not, we're still going to be interested in verifying her hardship. But, that's something we have to do behind the scenes with exchanges of documents, et cetera. She would like to show me documents now, but I'm in no position I'm not authorized to stipulate to a plan or not to a plan. I'm just here to obtain the judgment and then to facilitate additional communication with the defendant. So I would like to argue plaintiff's motion for summary disposition if that's necessary. But again, after that, my goal is going to be to try and establish contact with the defendant through the Buffalo firm so that she can document her hardship and maybe we can attempt to work something out.
Ms. Dunlap, were you able to hear Mr. Goldner just now?
Yes, I was. And I was explaining to him, I'm sorry, Your Honor. I was explaining
Go ahead,
to
Ms.
him.
Dunlap.
I was explaining to him my fear of law offices. I'm not saying all operate the same way, but my fear is that if there is a judgment and they pursue me without discussing it with me. And then the money that I have, I'm way behind on everything. And I don't mean 2 or 3 months. I mean, I'm very, very, way behind. And if they try to take any money from me, then I may very well be outdoors. That's what I was explaining to him. I do have records and documentation with me, and he said he couldn't see it at this moment. I have no problem showing it to the law office, but I didn't want a judgment against me because I know then by law that they can try to pursue to take money from wherever, and that would just hurt me. That it would be more detrimental than I'm in the situation now.
Ms. Dunlap, I understand and appreciate your situation. This court did receive your answer and did review it thoroughly. This court also received the plaintiff's motion for summary disposition and reviewed it, and the motion is scheduled for hearing this morning. The court did not receive a response from you to the motion. Was there something you'd like to say in response to the motion filed by the plaintiff's office?
I don't know what the motion was. I didn't send a response because I sent a letter in stating that I was suffering from financial difficulty and I'm way over my head. I'm drowning. So I didn't know I was supposed to respond again.
The court did receive your answer on September 15th. The plaintiff's office thereafter filed the motion on October 13th. The motion would have included a notice to appear, their motion, and their brief in support. So the question that I'm asking you is, have you received something in the mail from the plaintiff's office within the last 30 days or so?
I received something that said something about a payment plan. Is that it?
No, ma'am.
No, I didn't receive anything else.
This is approximately 10 pages.
I saw something about it. Call them about a payment plan. That's what I saw.
Your Honor, if I may, my information is that on October 7th, the Buckles firm mailed out the motion to the court and to the defendant.
But what is it saying? What is it requesting?
Included in the
Ms. Dunlap, it asked for entry of judgment.
Okay, and I was supposed to respond to that?
You don't have to respond, ma'am. You have an opportunity to respond. That's why my question to you is, this court has not received a written response from you, but is there something you'd like to say in response to the motion?
Yes, I don't want a motion against me. I'm more than willing to make payment if I could. At this time, I cannot. I'm having very, very a dire situation financially. And at this moment, I can't even squeeze a nickel out. I mean, really. And so at this point, I cannot. I don't want a judgment against me. But in the future, if I can pay, I definitely plan to.
Mr.
Right
Goldner,
now,
this court has had the opportunity to review the motion that was filed by the Buckles Law Firm, received by this court on October 13th. Is there something you'd like to add, sir?
No, Your Honor. I would just say that in addition to the fact that there is no issue of material fact as to the liability, I am only curious if the court received the proposed judgment for $5,819.49.
The court did.
Thank you, Your Honor. So the only thing I would add is, the judgment we're seeking is simply to follow the form. Some certain judgment plus court costs, no attorney fees, and no interest from charge off through today, statutory interest thereafter.
Ms. Dunlap, this court has had the opportunity to review the file in its entirety, including the plaintiff's complaint, your answer, and the plaintiff's motion for summary disposition. Ma'am, inasmuch as you have failed to state a valid defense in the answer that you filed with this court back on September 15th, the plaintiff's motion will be granted. The judgment amount will be principal damages of $5,616.18. There have been court costs to date of $203.31
Oh
for
my
a total
gosh.
judgment of $5,819.49. Anything else on behalf of the plaintiff in this matter?
No, Your Honor. Do you wish us to submit an order, or are you able to enter the order that we provided with the judgment, or with the motion, pardon me?
The judgment submitted with the motion has already been signed, sir. We'll go back downstairs for mailing to the parties. Anything else in this matter, Ms. Dunlap?
Yes, I'm wondering, did I have any rights in this case at all? I mean, I was given the paperwork in the letter. I told you what's happening with me. And I mean, because of COVID, I mean, I'm just, oh, gosh. So was it just frivolous that I showed up? I sent a letter, I appeared, I'm trying to tell you my situation, and I'm not getting any consideration at all?
Ms. Dunlap, you are receiving consideration. Your answer was reviewed, but there are rules that have to be followed. If a person disputes an amount, if they dispute an account, if there's some defense that they raise, it is the court's position that your answer does not raise a defense to the lawsuit. Your issue is a financial issue. And I'm not discounting that, and I'm not ignoring that, but a financial hardship is not a valid defense to a lawsuit.
So where am I supposed to get the money from if that's not a defense?
Ma'am,
how am I supposed to pay?
You can speak to the plaintiff's office about a payment plan. You can file a motion for a payment plan. Anything else, Mr. Goldner?
No, Your Honor, but as I stated for the record, I will have the Buckles office reach out with a financial hardship verification form, and we will make an effort to voluntarily work with the defendant after today. And I do appreciate the court's time very much.
Thank you. Anything else, Ms. Dunlap?
No.
We're all set. Thank you.
All right, take care, Your Honor.
You too. 213675 GC, Dakota Manor versus Ronald Manor. The parties indicated previously, their appearances have been noted. The parties indicated previously that there had been some communication back and forth. How are we proceeding this morning?
Your Honor,
I think, go ahead.
I'm sorry, Mr. Day, go right ahead.
Your Honor, we have talked some. My view of this, it might be beneficial to refer this over for mediation. I think a third party working with this might bring the two parties together. If you could give us maybe till sometime after the first of the year to do that and allow us to maybe exchange some other information. My client informed me right now he's down in Florida, won't be back in the spring, but if I do have some time, I can probably get some documentation from him, supply that to opposing counsel, and we can draft up a couple of mediation summaries and see if somebody can bring us together on a Zoom hearing.
Are you looking to do mediation here, or are you looking for case evaluation?
Either one, Your Honor. I'm looking for a third party that can kind of bring the two together.
And that was along the lines of what I was thinking as well, Your Honor. I have no objection to either mediation or case evaluation.
So we can get the mediation done within the next 60 days and schedule a matter for final pretrial February 1st, 2022 at 10 a.m. And I'll check with the civil department to see who they are using for the mediations.
And ask her where the rights notice.
And make sure that that order and notice reaches both parties. Anything else on behalf of the plaintiff in this matter?
Nothing further, Your Honor.
Anything else on behalf of the defendant?
No, Your Honor. Thank you very much for your time.
Thank you very much. You both have a good day.
Thank you. You as well, Your Honor.
Thank you. This is 210749 GC Speaker Law Firm versus Patrick Markulowicz.
Good morning, Your Honor. Ronald Bach here for Speaker Law Firm PLLC.
Mr. Bach, this matter was scheduled for a first pretrial at 10:15 a.m. It is now 10:27 by the court's clock. There are a few unidentified persons. Let me bring these people in from our waiting room and make sure that neither of them are your
Judge,
defendant.
they're not. They're for 10:45.
Thank you, ma'am. Mr. Bach, inasmuch as the defendant has failed to appear, how do you wish to proceed this morning?
I just requested a default judgment to enter, Your Honor. Let's say, and just drafting right now. We got the original damages, $3,300.87, cost of $167.47, statutory attorney fee at $75 for a total judgment of $3,543.34.
Again, inasmuch as the defendant has failed to appear this morning, the default judgment shall enter in favor of plaintiff and against defendant with principal damages of $3,300.87, $167.47 in court costs, $75 statutory attorney fee for a total of $3,543.34. Plaintiff will submit the default judgment to the court for entry. Anything else this morning, Mr. Bach?
Yes, Your Honor. How would you like me to submit that? Would you like that in the mail or email?
Email if your email's fine with this court, sir.
Okay. Is that on the notice?
It's civil
Okay.
at 34th District Court -mi.org.
Cool. All right. Thank you, Your Honor.
Thank
I think
you,
I
sir.
saw that
Have a
on
good
your
day.
website. You too. Thank you.
Okay. Bye-bye.
Good to see you.
Good to see you. Taylor, while I'm doing these other things, would you check with Sandy and see if we can refer cases over to dispute resolution and we can send this last case, this 213675 over to them for mediation? Thank you, ma'am. Ms. Kingsley.
Yes, good morning. Good morning.
Good morning, ma'am. This is 211548 LT Country Meadows versus Counts. George Counts and all other occupants. Your appearance, ma'am.
Good morning, Your Honor. Brianna Kingsley. 849.
Ms. Kingsley, today is the day and time set for this is scheduled for lack of progress. Hold on one second. Okay, Ms. Kingsley, the last time that we were here was August 3rd, 2021. We were scheduled for bench trial. You appeared, the defendant, I think it was Dana Counts, failed to appear. The default judgment was to enter for $2,676.01. It appeared that there was no default ever presented. And in reviewing the court's cases last night, there was a new case filed against this same tenant on October 29th, 2021.
Yes, Your Honor, I believe that's a duplicate. Reach out to my client on that one.
Ms. Kingsley, you keep cutting out. You said this is a duplicate file and what?
Yes, I believe the October filing, the duplicate filing, I need to reach out to my client to discuss that.
You're going to reach out to your client to discuss it?
Yes, Your Honor, because we also have action that's forthcoming.
Ms. Kingsley, there's something with your microphone. I don't know if it's when you turn your head that I keep losing you.
I'm sorry, Your Honor. Is this better?
That's okay. You were saying you were going to reach out to your client. You think it's a duplicate file because?
Because we were proceeding on a termination of tenancy action.
Well, then this court's confused. August 3rd, the defendant failed to appear for a bench trial. And then 2.5 months pass, nothing happens, and then there's a new non-payment case. So what are we to do with the 211548 LT case?
Well, Your Honor, I have a copy of the judgment that was submitted on August 3rd. So it was submitted to the court, so I'm not sure what happened.
I'm not gonna say we, I do not have it. I reviewed the files last Friday, noted this second case. I was not sure if the original case had been abandoned to pursue this October filing, but your suggestion to me is that is not at all what happened.
Correct, Your Honor, because the defendants have still
And
not
when you're,
paid. The defendants still have not paid the original judgment amount.
there is no original judgment amount. When your office received the lack of progress notice, which this court mailed out on September 28th, I would think that that would trigger someone to review our online ROA or call the court to see what happened with the judgment. So for purposes of this morning's hearing, it's scheduled for lack of progress. So is it your intention to resubmit the August 3rd default judgment or abandon this 211548 LT file?
Your Honor, it would be my intention to resubmit the August default judgment.
Please resubmit it. I'll send the file back downstairs if your office can get it in within the next couple of days. And then you indicated that the 214844 LT file was a duplicate. Duplicate meaning that your office will be dismissing it, or
Yes,
what's
Your
the
Honor.
status of that file? Okay. For purposes of this case, this was scheduled for 10:15 a.m. It is now 10:36 a.m. by the court's clock. Defendant has failed to appear. Plaintiff will submit the August 3rd, 2021 default judgment. And if your intention on the 214844 is to dismiss it, I would suggest that you get the dismissal in to the civil department. Ms. Kingsley, anything else in this matter this morning?
No, Your Honor, thank you.
Thank you, ma'am. Have a good day.
You as well.
Thank you. Oh, I just kicked her off. But we already have the dismissal in the other file. Well, pending. Mr. Levine, I do not see your other side. My
Morning.
usual wait time is about 15 minutes.
Okay.
Kay Ellis,
Yes.
your matter
Hello?
is at, I'm here. Your matter's at 10:45. I don't see your other side as of yet.
Okay.
Thank you. Just sit tight.
Okay.
I don't know who this is. Attorney for Midland.
Yes, Your Honor, Matthew Kuipers on behalf of Midland. I'm here on two matters. Jerome Williams and then Solomon.
Sir, would you like to speak to Mr. Williams?
Yes, be happy to.
Mr. Williams, you're going to see an invitation to join the attorney in the breakout room. Please go there with him to discuss your case, okay?
Okay.
Thank you, sir. Marianne. Taylor, were you able to get an answer to the question?
Thomas, what is your last name, please?
Look at the 1045, Marianne.
That's what I was thinking. I just wanted to double check.
I'm stepping off, Marianne, but I'm not going far. Exactly. My husband is like, where are you gonna put them? Mr. Levine?
I'm here.
210509 GC GTSC Warehouse versus Kazakowski and Kazakowski. Your appearance, please, sir.
Garrett Levine for the plaintiff. Good morning.
Good morning, sir. Oops. Today is the day and time set for the pretrial in this matter, first pretrial. The matter was scheduled at 10:30. It's now 10:44 a.m. by the court's clock.
This isn't a pretrial. We have.
I'm sorry.
Yeah.
I'm sorry. I'm sorry, Mr. Levine. Oops. I'm looking at two notes. This was a motion to allow execution on a judgment, and I had a note in the file because there is another case pending with West Village and these same tenants.
That would be for the site rent.
Yes, sir.
Yeah.
I understand that. My concern is always when you have impropers that receive two notices from the same court with issues they might think are the same issue, they're not appearance.
Okay.
That's just
That's
a
fair.
caution on my side, but they haven't logged on this morning, and this court did receive the plaintiff's motion to allow execution on the judgment for the claim and delivery. That motion was filed on October 4th, 2021, setting the hearing for today at 10:30 a.m. This court has not received any communication from the defendants objecting to or responding to your motion, Mr. Levine.
Yeah, I have not heard from the defendants either. Actually, my notes I haven't heard from them since July. And so we're asking the court to proceed on the judgment of claim and delivery. Since more than 28 days have elapsed, there's under 3-105, there's a requirement for notice to the defendants and an opportunity to be heard before the plaintiff in a claim and delivery may execute. So we provided notice to the defendants, gave them this opportunity to be heard, and they failed to appear or respond. I'm requesting that an order allowing execution be granted, and that the plaintiff be entitled to enforce its legal remedy to recover possession of the manufacturer.
Inasmuch as this matter has been properly noticed for hearing this morning, defendants having failed to appear, having failed to respond to or otherwise objected to the motion, it will be granted. Mr. Levine, I'm flipping through the file to see if your office submitted a proposed order with the motion.
I don't think we have. I don't see one in my file, so I could send one to you. later on today. Would email be okay?
Email is fine, sir.
Okay. Sorry, I didn't get that to you.
I'll make a notation in the file that you will submit an order to the court regarding today's motion. Anything else, Mr. Levine?
Well, thank you very much for your time. You have a nice day.
You too, sir. Thank you. This is 212498 GC, Midland Credit Management versus Jerome Williams. May I have your appearances, please?
How you
Good
doing,
morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
I'm sorry, counsel, the pronunciation of your name?
Matthew Kuipers.
Kuipers, thank you. Today is the day and time set for the first pretrial in this matter. The parties have had an opportunity to speak. How are we proceeding in this matter?
Judge, we have not come to a resolution at this point. We need to schedule this out. Plaintiff's requesting 60 days discovery and motion.
60 days discovery and what else, sir?
Motions. I'm not sure how this court does that, if the motions would be filed after close of discovery or during.
Sir, 60 days discovery puts you with a discovery cutoff of January 18, 2022. So the court would have the final pretrial / motion hearing date of February 1st, 2022 at 10 a.m. Back with me in courtroom number 1. If you would prepare and submit an order opening discovery, providing it opens effective immediately, closes January 18th, and the final pretrial again / motion date of February 1st, 2022 at 10 a.m. Mr. Williams, were you able to understand and hear everything that was just stated on the record?
Yes, I understand. I'm just, Your Honor, I'm just so like this case has been destroying me, like, and I really have done nothing wrong. I was sold a defective bed by Gardner White that they didn't remedy and fix until almost a year and some change afterwards. And I have the receipt, the final receipt from that. I had to call community just to get this done. And I didn't realize that until the near the end of when the account went delinquent. But I've been dealing with this for so long. And the fact of the matter is Gardner White sold me a broken bed from the beginning. It was broke. And I paid for a protection plan. So even if I didn't like the bed or whatever the case may be, I paid for a protection plan for them to, whatever the case, I can return the bed. They didn't honor that. They didn't honor that at all. And it should be documented up until the time when they finally sent somebody to look at the bed and take pictures, and they deemed it as defective, which I was saying from the beginning, but it just took a whole year. So, Midland, I don't even know who these people is. They've been at my house. They left a big envelope in front of my building, embarrassing me in front of my neighbors. They ping my credit report every month. Like this is and they have nothing to do with it. They just simply purchased this from community, and I don't know how that happened. They got everything redacted in their paperwork that they constantly send me. So I don't understand what they come up with that I got tons of paper I requested from the credit bureaus, even from them. And it's the same stuff, and they have no idea what happened or what went on between me and community and Gardner White.
Mr. Williams, this is just the first hearing in this matter, the pretrial. I have reviewed the complaint. I did review your answer, and I understand what your position is. This discovery period will give you some time to exchange information. If Mr. Kuiper's office has questions for you or request that you produce documents, he'll submit it to you in writing. You'll respond to it in writing. If there's anything you want from their office, same thing. You'll put it in writing, and they'll send their response to you in writing.
Your Honor, is there any
And
way?
between now, I'm sorry, Mr. Williams, and between now and our return date of February 1st, you may have whatever communication you need to have with the plaintiff's office. Don't feel like you need to wait till we get back here in February to discuss this matter. And my apologies, I just cut you off. You were going to ask me a question.
Is there any way, like, because some of this stuff is out of my control. Like the times when I called Gardner White, those records, it said before I get on the phone, this is being recorded for quality purposes. Is there a way they can get the pictures of the bed, the conversations that was had between community where the guy said I was wrong, even after the account was delinquent, already charged off. It's already charged off, and they still continuing to work with me to fix it because it shouldn't have got that far. I was paying on time. Everything I did right, except get the proper customer service that I was supposed to get, and it affected me. And I don't even know who these Midland people is. He doesn't work for them. So I can't get to the people who's supposed to have answers for me. I've already requested these things. And if you look at this receipt that I got, it has exchange numbers, original invoice numbers. Why can't they go and search for this information so they can accurately report this stuff? Because it's just, I can't do nothing with my credit. Every month they pinging me for this. Every month. And they're not even, that's a violation of my rights. And they're not even accurately reporting. And they just send me all of this stuff with redacted information and stuff that I already know. I know what the bill was, but it's not my fault that it got that far. I had a broken bed I couldn't even sleep in. So I'm sorry. It's just, I know I got to go through the process, but it's just frustrating. I got to take time out of my life when they could just send people who has nothing to do with the case. He couldn't even give me no answers. Like, who can give me answers? This place is from Minnesota somewhere. And they just go buy my credit, and they don't say what they bought it for. And they don't even have the price of what is the original debt. Like, so I'm sorry, Your Honor. It's just frustrating.
Mr. Williams,
going through this.
Mr. Williams, you're fine. Don't apologize. My question to you is, have you contacted an attorney or have you tried to get some assistance in this matter?
No, I guess I should. It just seems predatory, like you could just take something and you don't have the full scope of what happened. And then just say, oh, I'm gonna take over this debt. Now you gotta pay me. I get calls from them, letters, endless letters. It's just.
That's why I'm suggesting that maybe you and Mr. Kuipers, or if he's not the attorney that's going to be handling the matter going forward, you speak to their law firm, and there might be a way to resolve this matter short of returning here in February or anything else. I'm not sure. I'm just suggesting to you that that's an alternative, that maybe the things that you raised in your answer or the conversation you had with him, with the attorney this morning, caused the parties to have a different conversation.
Okay.
I know, Mr. Williams, trust me, I'm with you. I hear you. Mr. Kuipers, was there something you wanted to say, sir?
No, Your Honor. As I stated, we haven't come to an agreement. I should have said this earlier. I'm just here as coverage counsel. I do have all the files and records here. But if there's anything that can be worked out, I'm sure Midland's happy to work with Mr. Williams. That's why I suggested discovery. He can provide any documents that he might have to Midland, and maybe something can be worked out. But at this point, we're just requesting it be scheduled out. So.
I made the notes in the file. You would submit an order opening discovery and setting that motion cutoff date. Anything else on behalf of Midland?
No, Your Honor.
Anything else, Mr. Williams?
No, thank you.
I'll see you back here on February 1st, sir. Thank you. Mr. Kuipers, this is 210532 GC. This is Midland Credit Management versus Crystal Holland.
Yes, Judge. Matthew Kuipers on behalf of plaintiff. This is, I believe, a hearing for entry of a default judgment for failure to respond to a summons and complaint that was effectuated by alternate service. The order was granted by this court on April 6th. Mailing was effectuated on May 7th and tacking on May 26th. To this day, and to my knowledge, no has been received.
Mr. Kuipers, this court did receive the proposed default judgment. And although the court had previously entered an order for alternate service, I'm sorry, sir, I'm trying to flip through the file. This court received a phone call on May 20th, 2021 from a Rodney Rogers that indicated that the defendant did not live at the address and had not lived there since 2018, that he informed the process server of that information, and that he went to the Romulus Police Department to inform them of that as well. Based on that information in the court file, that was the basis for the denial. I just wasn't sure, could not tell from the notes in our file whether or not your office had received that same communication.
If they have, Your Honor, I don't have any notification or note of it. So that is news to me.
Well, Mr. Kuipers, the matter was scheduled this morning at 10:45 a.m. It is now 10:49 a.m. The defendant has failed to appear. The notice to appear for this morning that was mailed to the service address on October 27, 2021, setting the date and time for today's hearing, has not been returned to this court. How do you wish to proceed, sir?
Judge, based on the fact that the plaintiff did follow the court order alternate service and did serve the defendant properly per that order, plaintiff is requesting that a default judgment be entered on this matter.
Mr. Kuipers, if your office would be so kind as to submit a new default judgment, this court will sign it. Anything else this morning, sir?
No, Your Honor, that is it. Thank you very much.
Thank you. We're all set, sir. Have a good day.
You too.
Thank you. This is 213064 SC, Thomas Renowski versus Kathleen Ellis and Wildlife Control 911.
Thomas Narowski here, Your Honor.
Ms. Ellis?
Yes, good morning.
Good morning. State your name for me, please.
Kathleen Ellis.
Thank you.
Mm-hmm.
This is a small claims matter that was scheduled for mediation back on October 12, 2021.
Mm-hmm.
There seems to have been some confusion. The file came to this courtroom, I should say, for entry of an order, but I could not discern from the notes available what had occurred at the October 12th hearing, as there was some question about whether or not the notice of hearing for the October 12th hearing had gotten to the proper parties at the proper location.
What?
Have the parties?
Go ahead.
No, you go ahead.
Yeah, I'm just checking. What I have here is just to meet with you today. Notice to appear.
Miss Ellis,
that
turn your
right?
video on for me, please. Yep. There was a notice sent to 203 West Michigan and Saline that was returned to the court.
Yeah, that office is closed.
And so is the correct address the 88 Salem Circle?
Yes. Mhm.
Had the parties had any opportunity to speak regarding this matter?
We had a mediation. I don't know the date of that, the first one. It was a while back.
September 14th,
Okay.
where the only notes that are in the file indicate that the parties were to file more paperwork. And then the matter was adjourned to October the 12th, and no paperwork was filed. So at this point, I cannot tell from, that's why I started by saying I cannot tell from the notes in the file what happened or what was supposed to happen after the September 14th hearing.
Okay.
Mr. Narowski?
Yes, Your Honor.
Sir, this was originally your small claims affidavit and claim for $1,200, indicating that the defendant had failed to provide the services that were contracted for.
That is correct.
And sir, is it still your position that $1,200 is due and owing?
Let me backstep a minute, Your Honor, if I may. We had a representative.
Sir, I'm sorry. No, wait, I'm sorry, 1 second. There's something wrong with your video where I cannot, you're a blurred image, and Ms. Ellis, this court cannot see you at all. Would you please both activate your videos?
Oh, okay. How do you, let me see how I do that. Hang on. Start video. Okay.
Thank you.
Thank you.
And sir, I can see some outline, but I can't see you. Is there something with the video?
Your Honor, somebody else has brought this up to me in the past. I don't know what's going on. I just have no control over this.
What type of device are you on? Are you on a phone, a desktop, a laptop, a tablet?
No, I'm on a laptop.
And do you see where the video camera is?
Yeah.
Is it covered up by a piece of paper, a piece of tape or something?
No, it's not.
Sir, you were starting to say, let's back up for a moment. Where are we backing up to?
This is June 18th, 2020. Wildlife control representative came out.
No, sir, no, we're not backing up there yet. My question to you was, are you still owed $1,200? Your response was yes. Correct?
I'm not sure what your question is, Your Honor.
My question was, do you believe that you're still owed $1,200 from Ms. Ellis and Wildlife Control 911?
Yes, I do.
Thank you. And when the parties appeared on September 14th, the note in the file indicates that the parties both appeared and were to present more paperwork. Mr. Narowski, was there some other paperwork that you were supposed to submit?
I provided the court agent with a picture that displays a tarp that's still in the attic in our house, which means the service person would be returning at a future date to determine if the removal was effective. At this point, we have no way of knowing if the bat problem still exists or not.
It would be helpful to me, sir, if you would answer the question that I'm asking so I can figure out where we're going. Was there anything other than the photo that you needed to submit to the court to proceed on your claim, sir?
No, that was it.
Thank you. Ms. Ellis, was there anything else that you needed to present to the court to proceed on your defense to the claim in this matter?
You know, and this is my fault. Well, the company is not in business anymore. And what they were looking for, I think, which I sent, and then I had a problem with my fax, so I'm not 100% sure it went through. But what I have is just notice of change that all the paperwork was filed in March, that the company had closed. You know, we just got killed in COVID. We were around for 12 years, but that was enough. So I'm looking at the date that this was. But the company is not in business anymore. So that's all they were looking for. Or I have my employer account, any of those kinds of things that would also, I mean, it's pretty easy to find out that the company is dissolved.
Ma'am, the complaint, the affidavit and claim in this case lists you individually. So my question to you again is are the documents you need for your defense, have they already been submitted to the court?
I don't know that they went through. And that's what they wanted was that's all they were asking for is dissolution of the company.
There is a summary provided by the plaintiff in this case. There are copies of invoices dated June 18th. This second one is not dated, lists a 3-year warranty with a total of $1,651. There's the plaintiff's affidavit and claim. And there is the invoice for the service fee. Today is the day and time set for hearing in this matter. Ms. Ellis, is there something that you intend to present to the court in support of your defense of this claim?
Well, there isn't anything to give. I mean, we did the service. What he is disputing is that there is a inspection that my technician apparently said that we'd come out for the next couple of years and check to make sure there were no bats. The company's not in business anymore. The services were all provided. From what I understand and what he explained to me at the time, everything was done except he doesn't have any noises in his attic. He doesn't have anything like that. That's what he told me. So usually that indicates that there's not any bats anyway, but he's looking for an inspection, a follow-up that normally we don't do. So I'm not sure why my technician did that, but we do have a warranty if the bats were to come back in our seal up areas if they reopened. But there are no bats.
My question to you was, I've identified the paperwork that is in the court's file. Was there anything that you wanted the court to consider, or is there some documents that you wanted to present before the hearing is called and witnesses are sworn in this case?
Well, I don't think there's anything to give you other than the company is gone. I mean, I don't know what else to present. You know, when the company, we went through this at mediation, when the company closed, my software of all information was through a company that I rented from every month. When I cut that service off, they have all the records in their software. I mean, I don't have anything. I think Mr. Winowski was supposed to send something in, maybe a copy of the, I'm not really sure what he was, but anyway, there wasn't anything for us to give. Basically, just what they were asking for is a dissolution of the company. I don't have anything else to give.
Okay, that was my question. Was there something that
Okay.
you needed to file, needed to present? And if your answer is no, that's fine.
Okay.
And we can proceed. I would like to proceed to the hearing, but I cannot see the plaintiff. And I was trying to figure out, was there a way for us to figure out what's going on with your lens, sir?
Mm-hmm.
Mr. Narowski,
Yes, Your Honor.
you said that you don't see that the lens is covered or something, but I can't see you. I'm ready to swear you in and begin the hearing, but it's difficult when I can't see that you're even there. Is there someone there who, you said someone else usually helps you get on? Is there someone available?
No,
To make sure?
There is not, Your Honor.
Okay. Sir, are you ready to proceed with the hearing this morning?
That's why I'm here, Your Honor.
Okay. Sir, I am not comfortable proceeding when I cannot see you. So I don't know where to tell you to look on your laptop to determine what it is that's making your image obscured.
Let me close the laptop housing. Maybe that'll do something. Hold on a second.
Thank you. Sir.
Is there any difference in that?
Yes, sir. That's exactly what I needed. Your image is now crystal clear, sir. This is your claim. If you're ready to proceed, sir, would you raise your right hand for me? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can put your hand down. Sir, this is your affidavit. This is your small claims claim. Please proceed with your claim.
How shall I proceed, Your Honor?
My name is, I contracted with this company for, I paid them X, and I'm now requesting damages of X amount of dollars.
My name is Thomas Narowski. I contracted with Wildlife Control 9/11 in Saline, Michigan, and I'm looking for damages that I'd like to negotiate.
Damages that you'd like to negotiate?
Yes.
Would it be beneficial to the parties to go into a breakout room to negotiate a settlement, Ms. Ellis?
I guess so. I don't know. This should be the company involved in this. I'm not sure how I am involved personally.
Because Mr. Narowski listed you personally. If you do not want to go into a breakout room, we will proceed with the hearing in this matter. I just suggested it because Mr. Narowski just indicated to negotiate a resolution. So you don't have to go. And if you say you don't want to go, I'll continue with his testimony this morning.
I would say, let's just continue on.
Sir.
I'm fine with that.
In as much as the defendant wishes to proceed this morning, sir, you were saying that you contracted with Wildlife Control 911. And what happened, sir?
Her agent came out. His name was Dominic, and he told us that it appeared as though we had bats in our attic, and he said that it would be according to what he said, a process, and we prepaid a total of $1,800 for that remediation. And the most recent Wildlife Control 9/11 service agreement copy that were received identified things that would be put in there and also stated there would be 6 visits. We only received 2. And I understand what Ms. Ellis is saying about the COVID situation, but it would have been nice to reach out and notify her customers that things were shutting down. We had no way of knowing. And when we got late into the process early this year, we could not get a hold of anybody, which didn't make me very happy. So as a consequence, we're looking for the removal of the tarp that's still in the attic, which implies that the service person would be returning to determine if the removal was effective. We still have no way of knowing if the bat problem still exists. And I think we are at least due a couple of visits to confirm the fact that the bats are no longer there.
And Mr. Narowski, have you had any other company come out to look to see if there were any evidence or trace of activity up in that space?
No, I have not yet, Your Honor.
Okay. Sir, was there anything else you wanted to say?
In addition to having the defendant contract with somebody to come out and confirm that we don't have a bat problem anymore, I'd like to get $36 for the costs we had to incur to serve the notice to her.
Understood, sir. Anything else?
No, I think it's very reasonable.
Ms. Ellis, do you have any questions for Mr. Narowski?
Yes, but Mr. Narowski, you indicated before that you're not hearing any activity in your walls, ceilings, not seeing any activity outside, anything like that in the evening?
I don't go out in the evening, and the fact that they're not where they used to be is not evidence that it still doesn't exist.
Okay, well, I mean, what you're indicating is we did a seal up, we put in,
Ma'am?
Yeah.
If you have questions for him, ask him questions. If you don't have questions, we'll go on to his next witness and you'll have an opportunity to testify here shortly.
Oh, okay. There's another witness?
I don't know. We haven't gotten there yet.
Okay. No, other than we did a full job out there and with the prices he even gave me were, so I don't know what to, the company's gone.
So the answer to my question is no, you don't have any more questions for him.
No.
Thank you. Mr. Narowski, did you have any other witnesses or any other documents to present to the court?
Only what I have previously provided to the court representatives.
Thank you. Ms. Ellis, would you raise your right hand, please?
Yes.
Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ma'am, what is it that you'd like to say in response and defense to the claim filed by the plaintiff?
Well, the job was done. From what I understand, what his concern is an inspection a year later, which at max would be, I mean, our initial inspection ourselves for full inspection when we go out is $149. Now, I don't have anybody to do inspections now because the company is closed. We have no wildlife control 911. So, first of all, the $1,200 and some dollars, I don't know where he comes up with that figure. The job was completed and done successfully. If there's a tarp up there, that's just an indicator to show if there's any new activity. But, the company closed in March. That's where we're at.
Sir, do you have any questions for Ms. Ellis in this matter?
The only question I have is that your representative Dominic gave us a wildlife service agreement copy that stated 6 visits. We only received 2. And this whole process, as he mentioned, has never been completed because nobody has ever reviewed our attic to determine whether the bats are removed or not.
Well, he did at the beginning of the process. When he came back and did a seal up and one-way doors, and you had indicated that the one-way doors were taken down, right?
That is correct. He also stated he would be out in March or April of 2021 to confirm that the bats were indeed no longer present. And that's the issue I'm bringing up, is that I was not able to get a hold of anybody. Dominic's phone number went to voicemail, and the voicemail said, the mailbox is full, you can't get a hold of them. I called your office, and nobody ever responded to the voicemail messages that I left to those phone numbers. And it didn't make me happy perceiving the fact that we may have been ripped off.
Well, the service that you were provided is where the cost was. As far as you did have an inspection after we took down the one-way doors. During that process, Dominic, if that came down, he would have went up and inspected at that time to have no new activity. So that was good news. That means that the seal up worked. The bats would have came back during that time. We would have saw activity, and there wasn't any. So a year later, yes, we're missing an inspection after the fact because the company no longer exists. There's no technicians. There's nobody to take care of this at this time. The process of what you're talking about, the cost involved, was the seal up, and we also did the roof vent covers also, which he did, but from what I figured out on the prices, was much lower than we normally charge, which doesn't matter, but that's what he did over there. But all of that was completed.
Sir, do you have any questions for her?
No.
Ms. Ellis, is there any other witness you have this morning or any documents that you wish to present to the court?
No.
Mr. Narowski, do you have anything else you'd like to say this morning?
No, Your Honor.
The court has listened to the testimony of both parties this morning. And it is clear from the documents that were filed by the plaintiff in this matter that there was a contract between Tom Narowski and Wildlife Control 911. There is nothing included in any of the paperwork that has been submitted to this court that indicates that the defendant number one, that being Kathleen Ellis, agreed to be personally liable or responsible for any of the items listed in the contract. For that reason, there will be no recovery against Ms. Ellis. As for Wildlife 911, this court does not see service having been effectuated upon Wildlife Control 911. There is a proof of service that shows that service was made on Ms. Kathleen Ellis at the address that has been confirmed that was served on July 19, 2021. The plaintiff has also failed to produce any receipts, quotes, or proposals that would suggest that there is a value to the removal of the tarp from the attic or an inspection. There's been nothing submitted that would confirm what the damages would be. For that reason, there will be no recovery in this matter. Judgment shall enter showing no cause of action. There will be no recovery to plaintiff in this matter. The civil department will prepare the judgment and mail it to the parties. Anything else on behalf of Mr. Narowski?
No, thank you for your time, Your Honor. Appreciate your excellent service.
Thank you, sir. Anything else, Ms. Ellis?
No, I appreciate the time. Thank you.
Thank you, ma'am. Have a good day.
You too. Bye-bye.
Thank you. Mary Ann, we have files left. And I'm not sure. Trying to figure out. Twelve. 1, right? Golden. Young. Stewart. Southport. Johnson. That concludes our morning docket. We will stand in recess until 12 noon. Thank you.